Dear students, subscribers and the viewers, welcome to the IAS Mentor. This will be our lecture number 9 in the series Indian Polity, which is done with a major objective of providing a broader idea on the subject Indian polity, and in the process we'll also cover some of the important books relevant for UPSC IAS examination, which includes books like LAXMIKANTH, D.D BASU, and of course other relevant books as well, which would give a better idea on this particular subject. Now this series is not only relevant for the students preparing for the UPSC examination, but can also be really useful for the students preparing for other competitive examinations, including various state public service commission. With that, we'll move on to our next lecture, that is lecture number 9. In the last lecture, we tried to understand some of the important features of the Indian Constitution. We tried to understand some of the important features like what is democracy, what is parliamentary democracy, what is secularism, what is federalism with unitary bias, what is independent and integrated judiciary, and of course certain other important features as well. So understanding those features will help you in having a better understanding on the various topics that you are going to take as we'll proceed with the provisions of the Constitution. So that is like a fundamental before understanding before we get into the Indian Constitution. So on similar lines, before we proceed further to the Indian Constitution, that where we'll start with the topic of preamble. Before that, we shall also understand some of the key terms in polity. When I say key terms in polity, there are certain key terms which is specific to each and every subject. And similarly, if you see in polity, there are also certain key terms which is repeatedly used again and again. And so before I proceed into the preamble to the Constitution of India, I wanted the students to have a proper understanding of these keywords or the key terms, so that henceforth there is no need for me to explain it again and again, and it is also easier for you to assimilate and understand all those things. So this particular lecture and probably the next lecture will also be an explanation to probably the keywords, around 20 to 30 key terms or the words that you are going to repeatedly use in polity subject. So we'll move to the lecture. We'll try to understand some of the keywords that we are going to repeatedly use in the lecture. So first and foremost thing that I wanted to explain today is what does it mean by article, parts and schedules. I have already discussed about this briefly, but today I wanted to explain this in detail, because whatever you are going to study is about the Indian Constitution, and the Indian Constitution is nothing but the collection of various articles. The original Constitution had 395 articles, 22 parts and 8 schedules, which subsequently has gone for a change today after a lot of amendments that has happened to the Indian Constitution. And I already gave you the information as to how many articles, parts and schedules we have today, presently. So if you know the answer, you can also put that in the comment box. But however, the question is, what is an article, what is a part and what is a schedule? If you see what is an article, I would say an article is a specific rule, because what is Constitution? The Constitution is nothing but a collection of rules, or it is the fundamental rule book of the country, where it consists of collection of rules. So every article is nothing but a specific rule. That is what we can understand. Say for example, article 1 of the Constitution talks India, that is Bharat, shall be union of states. So that is a specific rule that is given in the Constitution. Say for example, article 21 of the Constitution talks about the right to life and liberty of an individual. Say for example, article 21A talks about right to free and compulsory education. Article 5 of the Constitution is related to citizenship. So in this way, if you see, every specific article in the Constitution is talking about a specific rule. So what is an article? An article is nothing but a specific rule based on which our country is to be governed. That rule will provide certain information, and according to which the country is to be administered, according to which the people will exercise their right, according to which people will get their citizenship, according to which the courts will probably function, according to which the legislature will probably function. So each and every single article is nothing but a rule. And then we'll have to have an understanding of what is parts. So what is a part? Part is nothing but collection of rules. So every article is a single specific rule. But whereas what is a part? Part is a collection of rules which deal with a specific matter. So there is a relation between certain articles, and those related articles or those related rules are put together in a specific part, and that's basically what is called as a part. At the commencement of the constitution, we had 22 parts, and today under the constitution we have got what is called as 25 parts. Say for example, Article 1 is talking about what? It is talking about India, that is Bharat, shall be union of states. Article 2 is talking about the power of the parliament to admit new state into India. Article 3 is talking about the power of the parliament to create new states within the territory of India. And similarly, so is Article 4, which is also dealing with a similar matter. So if you see, while every single article is a specific rule, and what is a part? A part is a collection of rules which deal with a specific matter. Part is something which deals with set of rules which are related to one another. So for example, Article 1, 2, 3 and 4 is clubbed under what is called as Part 1, and they all deal with a specific set of matter. Similarly, say for example, take the example of Part 3 of the Constitution. The Part 3 of the Constitution is titled as what is called as fundamental rights. And if you see, there are lot of articles within fundamental rights, right from Article 12 to Article 35. And every single article is dealing with a specific rule or a specific fundamental right. But however, all those things are dealing with what is called as the fundamental rights, and hence they are all clubbed under a particular part what is called as the fundamental right, or that particular part is titled as what is called as fundamental right. Similarly, if you see Part 2 of the Constitution, the Part 2 of the Constitution is from Article 5 to Article 11. While every specific rule under Article 5 to Article 11 is dealing with citizenship, a different aspect of citizenship, but overall they deal with the subject matter of what is called as citizenship, and hence they are all clubbed under the title of what is called as citizenship, and that is why they are considered to be Part 2, and Part 2 is titled as what is called as citizenship. And similarly, you can have a lot of examples. Say take the example of Part 4. While Part 4 is titled as Directive Principles of State Policy, so the entire article under Part 4 having lot of rules within Part 4, but they are all related to the Directive Principles of State Policy. So what is an article? An article is a specific rule. And what is a part? Collection of rules related to a particular subject matter. So that is basically what you will have to understand. And then the third important thing is what is called as a schedules. So what is a schedules? Schedules are nothing but tables or appendix which would contain information that would supplement whatever is the already existing information in a specific rule. So for example, a rule might give a lot of information. When you read Article 1, it talks about India, that is Bharat, shall be union of states. And if you read further Article 1, it also says that India has lot of states within India. And what are the names of these states? The names of these states are not mentioned in Article 1 itself. Although Article 1 is a source of all these things, Article 1 is saying to see the names of the various states in India and the union territories in India, you shall go and refer to the Schedule 1 of the Constitution. So although if you read Article 1, I am just repeating it again. Although if you read Article 1 is saying that the territory of India shall consist of the territory of the states, the territory of the union territories, and such other territory as may be acquired by the Union of India subsequent to the commencement of the Constitution. So while Article 1 is making it very clear what is the territory of India, but what are the states within the territory of India is not mentioned in Article 1. So Article 1 is saying that if you want to know all those things, you can go and refer it to the Schedule 1 of the Constitution. That means you should basically have an understanding. Although Article 1 is the source of all those things, but Article 1 does not have all these information mentioned in that particular rule itself, because that would make the Constitution not very organized. So for that particular purpose, to supplement certain information which is already given in a specific rule or in a specific article, and not to put it directly there itself, because then the organization of the constitution will not be so appropriate. And for that purpose, the Constituent Assembly has given certain additional information which is related to a specific article, but they don't want to place it in the article itself. And such information is actually placed in what is called as a schedules. So what is a schedule? A schedule is nothing but, I would say, an appendix, or it can be in the form of tables, but that contain additional information that would supplement the already existing information which is given in a specific article or in a specific rule. That's basically what you'll have to understand. So as of now, if you see the constitution today, there are 12 schedules, but the original constitution had 8 schedules, and that is all because of the fact the Constitution of India can go for an amendment. Amendment means basically change. So we'll try to briefly understand about that as well. So henceforth, whenever I use the word amendment, amendment means changes to the constitution. And that changes to the constitution can be done by the Parliament of India. The Parliament is the only authority to make changes in the constitution. So before I discuss about that, let us also quickly try to understand what we already read. So what is an article? An article is a specific rule. What is a part? A part is nothing but collection of rules which is related to one another. What is an appendix? An appendix is nothing but additional information which is given in the form of tables, which is given in the form of any of the other means, but however they are all related to a particular rule, or they supplement the information which is given in a specific rule. So that's basically what is called as a schedule. What is an amendment? Amendment basically means changes to the constitution. So today the Constitution of India has been amended 106 times. Right from the commencement of the Constitution, that is on 26 January 1950 till this point of time. How many times the Constitution has been amended? It has been amended 106 times. And who is having the authority to amend the Constitution? It is the Parliament of India. It is only the Parliament which has got the power to. And which article in the Constitution is giving this power to the Parliament? It is Article 368 of the Constitution which is giving this power to the Parliament. And based on that particular which is given to the Parliament has amended the Constitution. And over a period of time, the articles, the parts and the schedules in the Constitution has gone for a change because of the amendment which is done by the Parliament. But there are different ways by which you can amend the Constitution. So what are the ways by which you can amend the Constitution, or in other words, what is the procedure to amend the Constitution? We will subsequently discuss all those things, which is also given in Article 368 as to how the Parliament, or what is the process the Parliament has to follow to amend the Constitution. And you should also have this in your mind that the Constitution of India is amended through Article 368. And there are also certain amendments that can happen outside Article 368 as well. So the procedure in both the cases are quite different. However, most of the provisions can be amended only under Article 368 of the Constitution, and for which there is a need for a specific majority in the Parliament. And I will take one specific class to study about all these majorities, where I will explain about all those things. But however, from this class, what should be a takeaway is that whenever I use the word amendment, what is your understanding? Your understanding means amendment means changes in the Constitution. And to that extent, that is why we also call that the Constitution of India is nothing but an organic document, a document which can undergo a change. And that's basically what you should understand by the word amendment. The third important topic or the third important term that I keep repeatedly using is what is called as a right. So what is a right? In fact, there's a saying which is called as wherever there's a right, there's a remedy. So what does it mean by a right? Right is basically certain entitlements or certain privileges which is conferred upon the citizens. So we as a citizen, we are conferred with certain entitlements, or we are conferred with certain privileges probably, and it is our right to exercise and enjoy all those things. And what is the purpose for which this right is conferred upon us? It could be multidimensional. One of the objective could be that it will empower us to do well in our life. It will help us to do a variety of things to grow ourselves. It will help us to protect ourselves from the arbitrary action of the state. So these are all the various objectives as to why the rights are conferred. So basically, what is a right? A right is nothing but it's a privilege, or it is an entitlement which is entrusted upon us. But however, depending upon what type of right or what is the source of these rights, the rights can be classified into number of types. And there is also some type of hierarchy for these rights. What is the hierarchy for these rights? So depending upon where these rights come from. So that is how we'll have to look into these rights. Say for example, the rights can be classified into what is called as fundamental rights. It can also be called as what is called as constitutional rights. In certain time, it can also be called as what is called as legal rights. So is there any difference between the fundamental right, the constitutional right and the legal rights? Of course, yes, there is some element of difference. But one thing that is common when you talk of rights is whatever be the right, be it fundamental right, constitutional right or legal right, whenever it is violated, we have the right to enforce it in a court of law. Or in other words, whenever it is violated, we can approach the courts and seek a remedy because our right is violated. And rights are basically enforceable in a court of law. But however, what is the difference between these three rights? That is the fundamental right, the constitutional right and the legal rights. I'll also explain that with example. So first of all, what is a fundamental right? Fundamental rights are those rights which are mentioned in part 3 of the Constitution. Now whatever right that is mentioned in part 3 of the Constitution, only those rights are what are called as fundamental rights. Apart from the part 3 of the Constitution, even if the rights are coming from the Constitution, but if they are not mentioned in part 3 of the Constitution, then they are not called as fundamental rights. What are the rights or which rights are called as the fundamental rights? Only those rights which is mentioned in part 3. For example, the right to life and liberty under Article 21, right to equality, right to freedom of speech and expression, right to form association, right to freedom of movement. So these are all some of the rights which is guaranteed in part 3 of the Constitution. Right to freedom of religion. So these are the rights which are conferred in part 3 of the Constitution, and only those rights are called as fundamental rights. If there are any of the other rights apart from the part 3 of the Constitution, although it is mentioned in the Constitution, it is not considered to be what is called as a fundamental right. They may be merely a constitutional right, but not a fundamental right. Say for example, right to property was initially in the Constitution. But also specifically in part 3 of the Constitution. But however, today right to property is not there in the part 3 of the Constitution. So can right to property be called as a fundamental right? No, they are no longer a fundamental right, although they are still in the Constitution. So what is a fundamental right? A fundamental right is something which is there only in the part 3 of the Constitution. Say for example, the Constitution provides for what is called as right to vote. The Constitution allows for what is called as universal adult suffrage. So what is this right to vote? This right to vote, although it is provided in the Constitution, it is not a fundamental right, but it is merely a constitutional right which is guaranteed in the Constitution. So if the state is denying you the right to vote, you can go to the court. But they are not considered to be what is called as fundamental right, because whatever is given in the part 3 of the Constitution, only they are called as what is fundamental right. So why only certain rights are covered in part 3 of the Constitution? Because in the opinion of the Constituent Assembly, these rights are very, very essential for human survival. Very, very essential for a dignified human life. Very, very essential to protect them against the arbitrary action of the state. And hence these rights are protected in part 3 of the Constitution. And whatever is in part 3 of the Constitution, they are considered to be what is called as the fundamental rights. So this is basically, you should have an understanding. Okay, apart from part 3 of the Constitution, any of the other rights in the Constitution? Yes, they are all called as constitutional rights. Example, the right to vote. Okay, apart from the Constitution, if there are any of the other rights which is not there in the Constitution, neither in the Constitution nor in part 3 of the Constitution, but outside the Constitution. Because in India, there are a lot of other laws as well. Because I said very clearly, in any country which has got a written constitution, the Constitution is not the only rule book. Apart from the Constitution, there can be other rule books also. There can be ordinary laws of the land as well. And these ordinary laws of the land can also confer certain right upon us. Say for example, if there are any criminal activity that is done against us, if we are affected by any of the criminal activity, say for example somebody is hurting us, which we have not done anything to them, and then unfortunately we are hurt by the activities of other individual, then we do have the right to go and file an FIR in the police station. And that right to file an FIR is your legal right. Because it is not mentioned in the constitution, it is your right to file an FIR, neither in the constitution nor in the part 3 of the constitution. But this comes from the ordinary law of the land, which is nothing but the Indian Penal Code. Or sorry, it is coming from the Criminal Procedure Code. Sorry, a small correction. The Criminal Procedure Code. The Bharatiya Nagarik Suraksha Sanhita. So it is basically from this particular act we are getting this particular right. So these are all nothing but what is called as a legal right. So similarly, say let us assume you go and purchase a product or you get a particular service from a service provider, but then they provide what is called as a substandard service. So do we have any right against this? Yes. As a consumer, you have the consumer protection rights, which comes from what is called as a Consumer Protection Act. And this Consumer Protection Act is just an ordinary law of the land. It is not mentioned in the constitution. And such type of rights which you get from the ordinary laws of the land, they are called as your legal rights. So basically there are 3 rights which are enforceable as of now. But what is the similarity between all the 3 rights? That whenever these rights are violated, you can get it enforced in a court of law. You can approach the courts. So while the similarity is that yes, if they are violated, we can get it enforced. But however, what is the differences between these rights is that where you can get your rights enforced. That's basically the difference that you have to understand. So where you can get these rights enforced, in case of violation of the fundamental rights, you can directly approach the Supreme Court of India. And you can directly approach the Supreme Court of India under Article 32 of the Constitution. Or you can also approach the high courts in our country under Article 226 of the Constitution. But whereas in case of violation of your constitutional right or in case of violation of any of your legal rights, it is not possible that you can approach the Supreme Court of India directly. Yes, probably you can go to the Supreme Court, but not directly, only by a way of an appeal you can go to the Supreme Court. Now, what is the reason as to why in case of fundamental rights we can approach the Supreme Court directly, not in case of the other rights? It's because the Constituent Assembly thought that the fundamental rights are so important and they are very highly placed in terms of their priority, or these are the rights which are very essential for a human being to perform well in order to achieve what he wanted to do. And hence if these rights are violated, hence there should be an immediate remedy for that particular individual, and hence they are allowed to directly move to the Supreme Court. If they are not directly allowed to move to the Supreme Court, then if they have to go from the lower court and by an appeal they will go to High Court and then by an appeal they will go to the Supreme Court, it will take a long time before they will get the remedy. And hence to prioritize and to give them immediate remedy, that the provision in the Constitution has allowed them to directly approach the Supreme Court of India, or they can also approach the High Courts under Article 226 in case of violation of the fundamental rights. But whereas remember, in case of violation of the ordinary legal rights or in case of the other constitutional rights, they cannot directly go to the Supreme Court, but they have to follow the ordinary hierarchy of courts. So this is basically we'll have to understand as to what is a right in the first place and what is the difference between fundamental right, constitutional right and a legal right. Fundamental right, which is there in part 3 of the Constitution, constitutional right in the Constitution but outside part 3 of the Constitution, legal right which comes from ordinary laws of the land. And sometimes even a right which is mentioned in the Constitution outside part 3 can also be called as a legal right interchangeably under certain circumstances. Why? Which I will discuss it later. Okay, so but right now have this basic understanding. Whatever is in part 3 is a fundamental right. Outside part 3 but within the Constitution, constitutional right, right which is coming from the ordinary laws of the land like the Consumer Protection Act, which gives you the consumer protection in case of substandard service, then that is an ordinary legal right. Alright. In fact, there are a lot of legal rights which we do have. So this is just one example that I have given. Now come to the next keyword, that is basically what is called as writs. I am sure that most of you might have heard about this particular word writ. Now what does it mean by writ? To put it in a very simple way, a writ is nothing but a directive which is issued by the courts. Writs are nothing but what? Directives issued by the courts, especially by the constitutional courts, that is the Supreme Court and the High Court. Today they can issue writs. And when they will issue the writs? They will issue the writs whenever the affected individuals go to the courts, especially in case when they say that their fundamental rights are violated. Say for example, if my fundamental right is violated, I can approach the court and inform the court by filing a petition that my fundamental right is violated. So when I make this petition in front of the court, then the court will issue an order to the concerned authority to verify whether this right has been violated or not. And if the court finds that there is a violation of the fundamental right, then they may give the remedy. So that is why they issue this particular order, and that order is what is called as writ. In fact, under the Constitution of India, the courts can issue 5 types of writs. So what are the writs that can be issued by the courts? The Supreme Court of India can issue 5 types of writs. They can issue writ of habeas corpus, they can issue writ of mandamus, they can issue writ of prohibition, they can issue writ of certiorari, and they can issue writ of quo warranto. So these are the 5 types of writs that can be issued by the Supreme Court under Article 32. That is what is very, very important. And the Supreme Court of India can issue these writs only in case of violation of the fundamental rights. And the word only is very, very important. That means the Supreme Court, when they can use these writ powers to give these directives, if anybody goes to the Supreme Court informing them that their fundamental rights are violated, and that is under the only circumstances they can use these writ powers. But what is the difference between these writs? So we don't have to worry about this at this stage. When I take up Article 32 of the Constitution, I will discuss about these writs one by one elaborately. But for time being, what should be your understanding is that the Supreme Court can issue these writs or directives only when there is a violation of the fundamental rights. And different types of writs are issued when there are different types of fundamental rights are violated or under different cases. So depending upon the nature of the case, the Supreme Court can issue different types of writs. So right now, try to have this understanding. Now one more thing that you have to remember before we proceed further is it only the Supreme Court that can issue writs for the protection of fundamental rights? No. In addition to the Supreme Court, the High Courts can also issue writs for the protection of fundamental rights. And I have just discussed the article before some time and also in my previous lectures. So if you know the answer, you can put it in the comment box. Which article in the Constitution is giving the power to the High Courts to issue writs for the protection of fundamental rights? In case of Supreme Court, it is Article 32. But what is the article in case of the High Courts? So now both the High Courts and the Supreme Court can issue writs for the protection of what is called as fundamental rights. But although they derive these powers from different provisions in the Constitution. So that's basically what you'll have to understand by writs. Now the next keyword that you have to understand is what is called as the power of judicial review. Now judicial review is a power which is given to whom? Judicial review is a power that is given to the judiciary. In fact, this is nothing but this is part of the principle that you have learned in the last class. This is part of the principle of separation of powers. So what do you understand by this principle of separation of powers? That different organs in the Constitution are given different powers. The legislature, the executive and the judiciary are given separate powers, and the power that is entrusted upon the judiciary is to review the actions of the other 2 organs of the state. And if the other 2 organs, that is the legislature and the executive, if they perform any action which is in violation of the Constitution, and those actions can be struck down as null and void, that is legally invalid by the courts, by exercising their power of what is called as judicial review. For example, the Constitution says that nobody shall be arbitrarily arrested. So protection against arbitrary arrest is a fundamental right which is there in part 3 of the Constitution, which we will see later. So the Constitution is protecting every citizen or every individual in our country from what is called as arbitrary arrest. But suppose, say, let us assume the police is arbitrarily arresting an individual, arbitrarily arresting a citizen. In that case, will the judiciary is in a position to strike down that particular action of the police? Yes, by exercising their power of what is called as judicial review. Or in other words, say let us assume if the legislature is making a law which is in violation of the fundamental rights. Suppose let us assume a law is made by the parliament or by any of the state legislatures in India, and that law is violative of the fundamental rights. So can those laws be struck down to the extent it is violative of the fundamental rights? Yes, the judiciary can do that using its power of what is called as judicial review. So what do you understand by the power of judicial review? It is the power of the judiciary to review the actions of the legislature as well as that of the executive, and if they are found to be in violation of the fundamental rights, or if they are found to be in violation of any of the provisions of the constitution, then such actions can be struck down, and that's basically what is called as judicial review. So in fact, we'll have to understand the judiciary, in fact the Supreme Court, which is the highest court in India, is the protector and the guarantor of the fundamental rights in the constitution. They are not only the guarantor of fundamental rights, but they are also the protector of the constitution of India, and hence any actions of the other two organs which is not in line with the provisions of the constitution, they can be struck down by using their power of what is called as judicial review. So this is basically what you'll have to understand. To make it further easier, one small example let me give you. I'm not sure how many students are aware of this particular thing, but probably some of you might be aware of the section 377 of the Indian Penal Code. If you see the sections 377 of the Indian Penal Code, I'm not sure what is the section right now in the new version of the Indian Penal Code. If you see the section 377 of the IPC, the erstwhile IPC, in that section was criminalizing what is called as the lesbian, gay, bisexuals and transgender form of sexual orientation. Or in other words, the LGBT sex or sex against the order of nature was criminalized. But however, this section 377 of the IPC was challenged in the Supreme Court, and the Supreme Court read down this particular section. Read down means it has not completely struck it down, but it has made some of the provisions of the section in some of the readings or some of the wordings in section 377 of IPC as invalid. Now why they have read down some of the sections of section 377 of IPC is because of the fact the Supreme Court found that the wordings in section 377 of IPC is inconsistent with the fundamental rights. And to that extent, the Supreme Court has exercised its power of judicial review and it has read down section 377 of IPC, and thereby today the lesbian, gay, bisexuals and transgender sexual orientation is not a punishable offense and it has been decriminalized. Now why it has been decriminalized? Because the Supreme Court said that the sexual orientation of everybody should be equally protected. So normally if a sexual orientation of a heterosexual individual is protected under the constitution and if it is not a punishable offense, you should also protect the sexual orientation of others as well, because the constitution provides for what is called as right to equality under Article 14. And most importantly, sexual orientation of any individual is part of the right to privacy, and right to privacy is a fundamental right implied under Article 21. If sexual orientation is part of their right to privacy, and if right to privacy is part of their fundamental right, then how can you punish an individual for exercising their fundamental right? So some wordings in section 377 of IPC is inconsistent with the fundamental rights, and hence to that extent we have to read down these provisions, and they have read it down. So to that extent the lesbian, gay, bisexuals and transgender sexual orientation is not a punishable offense. However, under certain circumstances it may be a punishable offense. So generally it is not punishable. Suppose if the sexual orientation is not on the basis of consensus, although it may be on the basis of consensus, but it is between an adult and a minor. So under these circumstances it is still a punishable offense. But otherwise, if the sexual orientation among the adults and it is on the basis of consensus, and if it is happening in a private space, then it is no longer a punishable offense. And this has been done by the judiciary by exercising its power of what is called as judicial review. So this is basically what you'll have to understand by the concept of judicial review. So whenever I use a word article, you should have an understanding of what is an article. You should be able to understand what is a part. You should be able to understand as to what is schedules. So when I use the word amendment, you should be in a position to understand that it is nothing but I am referring to changes in the constitution. Rights, basically entitlements and privileges, and they can be enforced in the courts. And what type of right? When I say fundamental right, in part 3, constitutional right in the constitution but outside part 3, legal rights, these are all rights coming from the ordinary laws of the land. But although all the things can be enforced, but only in case of fundamental right, we can directly go to the Supreme Court. Writs, these are basically tools or powers in the hands of the courts to issue certain orders to enforce and to protect the fundamental rights. Okay, so that is basically what is writs. Judicial review, power of the courts to review the actions of the other two organs of the state. So this is basically what is called as judicial review. So now we'll move to the next term, that is basically what is called as locus standi. Now what do you understand by locus standi? It is a term which is in general used, but it is more related to the judiciary in the context of the Indian polity. Locus standi means, suppose it's a question that has been asked to a particular individual, what is your standing in this particular case? Or in other words, in which way you are related to this particular case, and that's basically what is called as locus standi. For example, if I go to the court telling that some of my rights are violated, and thereby I also establish in front of the judiciary what is my connection in this particular case, or how am I affected because of this particular case. So in case if I am affected because of anything that has happened to me, then it is part of my right, because I have a locus standi in that particular case, and hence the cases may be entertained. That was how the conventional policy of the judiciary. So whenever an affected individual goes to the court, the first thing that the court wanted to know is what is the locus standi of that particular individual. Or in other words, the court wanted to know what is your standing, or in which way you are affected because of this particular case. Because the conventional principle was only the affected individual can knock the doors of the judiciary to seek the remedy, and that's basically what is called as a principle of locus standi. But however, today the principle of locus standi has been diluted. And to what extent it has been diluted? So not necessarily only the affected individual should knock the doors of the judiciary. It can also be filed by any public spirited individual. Not necessarily personally he is affected because of something which is happening in the society, but he is a public spirited individual. He thinks that a lot of other people in the society are getting affected, and probably on their behalf he wanted to file a petition in a court of law. And today the judiciary is also entertaining such type of petitions, and such type of petitions is what is called as public interest litigation. So while what is a locus standi? In locus standi means that a person is affected because of certain issue, he himself is filing a petition. That means he is having some kind of interest in this particular case, and thereby there is a locus standi. But someone who is unrelated to something, but still he files a petition, and which is still accepted by the court. So in this case, the individual has no locus standi in this particular case, but still this petition is accepted by the court as what is called as a public interest litigation. So we'll have to understand as to what is this public interest litigation, which I'll subsequently discuss. Probably in the next class I'll discuss that more. But for time being, what is the understanding you should have? For time being, the understanding you should have is that what is locus standi means that an affected individual is knocking the doors of the judiciary, filing a petition, and he is also establishing as to what is his connection in this particular case, or what is his standing in this particular case. And if he is able to prove his standing, then he has a locus standi. If somebody is not having any standing or relation in a particular case, then there is no what is called as locus standi. So please come to the next key word, that is what is called as a nominal executive. So what do you understand by nominal executive? A nominal executive means that someone who is holding the position of authority, or he is a formal authority, or he is a symbolic authority, but the real power does not vest in the hands of that particular authority. And so all such authorities are what is called as nominal executive, or in other words, we also call them what is called as a de jure head. For example, under the Constitution of India, the president is the head of the union executive, and all the actions of the union government are taken in the name of the president. So this is what the Constitution says. But however, is it the president who get to decide all the things? Is it the president who is the real decision making authority under the constitution? Or in other words, is the president of India a real executive or a nominal executive? Is the president of India a de jure executive or a de facto executive? So the president of India under the constitution of India is merely a nominal executive. Or in other words, he is a formal head. He is a formal authority, no doubt. He is a symbolic head, no doubt. The constitution says he is the head of the union executive. But however, the constitution also says that the president of India has to act in accordance with the aid and advice of the council of ministers. That means the president in most of the cases, subject to some exceptions, we'll discuss those exceptions at the later stages. But however, the president of India, subject to certain exceptions, in most of the cases, he has to act on the aid and advice of the council of ministers headed by the prime minister. That means although the president is a formal head or a symbolic head, he doesn't get to decide the things on his own, but on the aid and advice of what is called as a council of ministers, who is headed by the prime minister of India. So that means the president of India under the constitution is merely what is called as a nominal head or what is called as a de jure head. A similar position is also occupied by the king or queen, the monarch in case of United Kingdom. So that is basically what is called as a nominal head or a de jure head. On the contrary, there is also something which is called as a de facto head. Who is a de facto head? A de facto head may not be a formal authority, may not be someone who is holding the authority as per the constitution, but he is a real authority when it comes to the practical execution or the way the decisions are made. So for example, the prime minister of India is not the head of the union executive. Although he is not the head of the union executive as per the constitution, but as per the other provisions in the constitution, he is the de facto power center. That means he is the one who get to decide the things. So that is what is the understanding you should know between what is called as a nominal executive, who is also a de jure head, versus what is called as a de facto head. So the president of India is merely a nominal executive. So similarly, if you see the governors in various states in India, the governors under the constitution of India are also nothing but what is called as they are also nominal executive, or in other words, they are also what is called as de jure head. So now we'll move to the next concept, that is what is called as electoral college. Now what do you understand by an electoral college? The simple understanding that you should have by an electoral college means it's a group of people, a body of people who shall have the right to vote, to elect certain authorities. And that's basically what is called as an electoral college. Now under the constitution of India, there are number of electoral college when it comes to electing different authorities. Say for example, to elect the president of India, you might be knowing that the president of India is not directly elected. The president of India is elected only by an indirect election and not by a direct election. So this is very important. How the president of India is elected? The president of India is elected only by an indirect election and not by a direct election. When I say the concept of direct election, so direct election means it is always elected by all the eligible voters, all the people, probably all the adult individuals. But whereas when I say indirect election does not give the voting rights to all the people, but indirect election gives the voting rights only to those people who are part of the electoral college. So for electing the president of India, there is a separate electoral college. Not necessarily all the citizens of India, not necessarily all the adult individuals. Only those people who are part of the electoral college, only they will have the right to vote, and the others will not have the right to vote. So that is the basic understanding you should have. So what do you understand by an electoral college? To put it in a very simple way, electoral college means it consists of a body of people, a group of people, and only those people who are part of the electoral college will have the right to vote in certain elections. So for example, for electing the president, there is a separate electoral college. For electing the vice president of India, there is a separate electoral college. For electing the members of the Rajya Sabha, there is a separate electoral college. So in this way, for election to different authorities, we have different electoral college, which is given in the constitution itself. So whenever I use the word electoral college, you should understand that I am going to discuss about a group of people or a body of people who will have the right to vote, and that's basically what is called as an electoral college. So I am sure that your understanding to all these things are quite clear. What is an article, part and schedule? What does it mean by an amendment? What does it mean by rights? Especially the difference between fundamental right, constitutional right and legal rights. What is writs or what are writs? What is judicial review? What does it mean by the principle of locus standi? What does it mean by nominal executive? Who is a nominal executive under the Constitution of India? And of course, what does it mean by an electoral college? So we'll see few more key terms before I complete this particular lecture. But however, I'll continue this particular lecture in the next, continue this discussion of key terms in the next lecture as well, because our list is quite longer. But however, I'll try to explain few more things before I wind up the class. Now the next thing is the first past the post system. Have you ever heard of the first past the post system? It is one of the principle that is used in the elections in India, especially the elections to the Lok Sabha and the election to the Legislative Assembly are based on the principle of first past the post system. So that's basically what you'll have to understand. So let us try to understand with this particular figure that is in the screen. You can just have a look into it. What do you understand by first past the post system? Say for example, let us assume that there is a 100-meter running race. In the 100-meter running race, suppose let us assume that 5 candidates are contesting this running race. And who is usually considered to be the winner of this particular running race? As far as the rules that we know that anyone who crosses the post first would be the winner. So that means out of the 5 candidates who are running this particular race, whoever is able to cross the post, that the finish line first, would be the winner. So he doesn't have to cross it within 10 seconds or he doesn't have to cross it within 12 seconds. There's no requirement of all those things, but he should be faster than the other candidates when it comes to a running race. So similarly, you apply that particular principle of whatever we discussed in the elections to the Lok Sabha and the election to the Legislative Assembly, then that is exactly what is called as a first past the post system. Say for example, let us assume that there are 4 candidates contesting from a particular constituency. Let us assume the elections to the Lok Sabha for easier understanding. And for the Lok Sabha elections, how many constituencies are there in India? I have already discussed that. But anyways, we'll have a discussion of all these things when I take up the parliament part later. But if you know the answers, you can put it in the comment box as to how many constituencies are there in India to the Lok Sabha elections presently. And which state in India has the largest number of constituency for the Lok Sabha elections. So you can put the answers for both the things in the comment box. Let me see how many students are able to put it correctly. Anyways, coming back to our understanding of what is first past the post system. So what do you understand by first past the post system? So first past the post system means, suppose let us assume 4 candidates are contesting election from a particular constituency, and suppose let us assume there are 100 voters. So how many people are eligible to vote? There are 100 voters. So all the 100 people are voting, let us assume, in the elections. And 4 candidates are contesting, 100 people are voting. So who would be declared to be the winner of this particular election? Is it someone who gets a majority? The majority of 100 would be 51. Or is it someone who gets more votes than the other candidates would be declared to be the winner? So if you apply the principle of first past the post system, as we have seen in the case of the running race, there is no need to get any minimum number of votes. There is no need to get any number of fixed number of votes. All that the winning candidate has to ensure is that the winning candidate has to get more number of votes than the other candidates. The winner should get more number of votes than the other 3 candidates contesting the election. Then automatically he would be considered to be the winner of this particular election. And that's basically what is called as the first past the post system. So take this particular example. Suppose let us assume 4 candidates are contesting A, B, C and D. And here this figure clearly tells that A, B and C combinedly they get 68 votes. Let us assume 68% of votes or 68 votes. And then D alone gets what is called as 32 votes. But however, combinedly they are getting 68, which is more than what D has got. But D has separately got more than the other candidates, all the other candidates, because none of these candidates among A, B and C have got what is called as 32 votes. So among the 4 candidates who have got the maximum number of votes, whoever has got the maximum number of votes would be the declared to be the winner when you apply the principle of what is called as first past the post system. And where is this first past the post system is applied? The first past the post system is applied in election to what is called as the Lok Sabha and the election to the legislative assemblies in India. So that's basically what is called as the first past the post system. All right. So that means there is no need for any electoral quota, or there is no need for any majority that they have to get. All that they have to ensure is that they have to get more number of votes than the other candidates. And where is this principle applied? This principle is applied in election to the Lok Sabha and to the legislative assemblies in the states. And then a principle that is opposite to that, the first past the post system, is what is also called as a proportional representation. In fact, there are different types of proportional representation, but I don't want to make it very complex. But to make the understanding very simple as to what is a proportionate representation, you will have to understand, in case of first past the post system, individual candidate is chosen as a winner if he gets more number of votes than all the other candidates who is contesting the election. But whereas on the contrary, in the first past the post, on the contrary, in the proportionate representation, there is a possibility that the people might vote to the parties and not to the candidates. So to whom the people might vote? They might vote to the party. Say for example, let us assume that there are 4 parties contesting the election. Assuming that, again Lok Sabha elections, assuming that there are 4 parties, party A, party B, party C and party D. And suppose let us assume that party A is getting 20% of the votes from all the constituencies. Overall, they are getting 20% votes. And party B is getting 20% votes. Party C is getting 25% votes, and party D is getting, let us assume, so 20, 20, 40, 65 and 35. Or for the easy understanding, let us assume party A is getting 25% votes, party B is getting 25% votes, party C is getting 25% votes, and party D is getting 25% votes. So overall, the 100% of votes is shared by all the 4 parties, and they almost get equal number of votes in terms of the percentage. So now let us assume there are 500 seats in the Lok Sabha. Of the 500 seats, now these 4 parties will have representation depending upon the vote share they have got in the Lok Sabha elections. So party A has got 25% votes, party B has got 25% votes, party C has got 25% votes, and party D has also got 25% votes. And total number of seats in the Lok Sabha is 500. So every party will get to have 125 seats in the Lok Sabha, because the number of seats in the Lok Sabha is proportionate to what is the votes or the vote percentage that they have got in what is called as the elections. So this is basically what is called as a principle of proportionate representation. But however, there are a lot of other types of proportionate representation also, but basically this is what is called as proportionate representation. So there are certain elements of proportionate representation under the Indian Constitution which I will subsequently discuss when I take up the appropriate area. But for time being, you can understand what is the difference between first past the post system and the proportionate representation. So this is basically what you will have to understand. All right. So please come to the next topic or the next keyword in the Constitution that we have been discussing is what is called as open ballot and the secret ballot system. The concept is quite simple as to what is a secret ballot system and what is an open ballot system. So first thing that we wanted to understand is what is called as the secret ballot. Now what do you understand by secret ballot? Whenever I use the word secret ballot, so this is basically what you will have to understand, that whenever you go to vote in the polling booth, nobody will get to know to whom you have exercised your voting, and that is basically what is called as a secret ballot system. I am quite sure some of the students who are watching this particular lecture, they might have an experience of either voting in the Lok Sabha elections or in the Legislative Assembly elections. So when you enter into the polling booth, you will enter into a cabin where nobody will be able to see to whom you are voting, and that's basically what is called as a secret ballot, or the sanctity of your voting is maintained as a secrecy. and that is basically what is called as the secret ballot. So you can understand that people walk into the polling booth, they go to respective cabin and probably they might vote there. Nobody else get to know about this. That's basically what is called a secret ballot. And where it is usually followed in the elections to the Lok Sabha, election to the legislative assemblies, in certain other areas also it is secret ballot. But then on the contrary, there is also something which is called as an open ballot system. What do you understand by open ballot system? An open ballot system is something where you are voting in the open. So look into this particular figure, look into this particular diagram. So people are raising their hands, which means if something is asked upon where they openly vote upon, saying that yes, we agree with this or we disagree with this in front of all others, so others can get to know whether you are in favor of it or you are not in favor of this. And basically such type of voting is what is called as open ballot voting. Now you might have a question where this open ballot system is followed in India. In fact, in most of the cases, the voting happens in the parliament is through what is called as open ballot. That means suppose in the parliament, if any proposal is introduced and if that proposal is put to vote in front of the parliamentarians, most of these proposals are done through what is called as open ballot, and it is not through what is called as secret ballot. The presiding officer of the house, who may be speaker or the chairman in case of Lok Sabha and Rajya Sabha, whenever something is to be discussed in the house, he might ask, okay, how many of the members are favor of this particular bill, or how many members in the house are favor of this particular proposal, and then probably he'll ask them to raise their hands, and those who are in favor will raise their hand and they will say yes or yay, and those who are not in favor, they will raise their hand and they will say what is called as no. And that is basically what is called a system of open ballot. So try to understand the concept of open ballot and secret ballot. And apart from this, we also have the other keywords, but probably we'll discuss the other keywords in our next lecture. So I'm quite sure whatever you have learned today, you should have a proper understanding, especially the concepts like first past the post system, proportional representation, what is open ballot, what is secret ballot, what is judicial review, what is difference between article, parts and schedules, and of course the other things that you have discussed. So now we will go to the practice question session, and we have certain other key terms also, but I'll discuss that in the next class. But I wanted you to solve this particular practice question, and I'm very sure that you have watched the lecture carefully. You should be in a position to solve this particular question. So come to the question. In case of violation of which of the following rights, we can directly approach the Supreme Court of India? Statutory right, right to vote, fundamental rights, all of the above. So in which of the case we can directly go to the Supreme Court? So what does it mean by statutory right? Statutory right means right that is flowing from the statute. Statute means ordinary laws of the land. Say for example, the Criminal Procedure Code gives you the right to file an FIR. Say for example, the Consumer Protection Act gives you the right to protect your consumer rights in case of substandard service. These are all statutory rights, which is also called as legal rights. So statutory right, right to vote, fundamental rights, all of the above. In which of the case you will have the right to go directly to the Supreme Court of India is the question, and you can put your answers in the comment box. So with that, we are coming to an end of this particular lecture, that is lecture number 9. But not this particular topic. So we are yet to discuss another 10 to 15 key terms in the polity, but I want to do that in the next lecture so that you can also observe most of the things. And in case if you want to reach out to me through any of, and if you have any queries and any other thing related to the examination, and if you want to reach out to me, you can reach out to me through my Telegram channel or through my Instagram account. And in case if any of your friends or family members are preparing for the UPSC exam, or any of the other competitive examination, you can refer this channel to them, and I'm very sure that it will be immensely beneficial to all those candidates. Thank you very much. All the very best. We'll meet again.